It's not in the face! Thank you.
Hi, welcome to Hey Not the Face. This is John Nash, your host. I'm flying solo today without Crooklyn, so this will probably be a mess of a show, but we are going to try to do the best we can because we're going to cover the last 3 days of hearings in the UFC antitrust case. That's all I'm going to cover today. If you're interested in that, you've tuned into the right show. But first, I want to remind people before Stephanie cracks my knuckles for getting this wrong. I want to remind people that they should subscribe to the show if they are not already a subscriber. We're Substack. So subscribe. If you're interested in the content of this type of business side of combat sports, we also have a paid subscription, which gets you behind the paywall for other episodes. I think this one will probably be free because, you're only getting half the crew today. So it's the behind the paywall crew is not here. But love to have you. If you want to, it's $5 a month. That's it. So feel free to subscribe if you like the content too. And you want to help support us besides subscribing and paying for subscription, you can help promote it. Thumbs up on YouTube, thumbs up on whatever app you're listening, forward it to your friends, share it on X, Instagram, Blue Sky, whatever the hell you use. That's helpful as well. So I apologize too for my voice. I am a little out of it today. It's late here. I'm in Minnesota. I'm in Minnesota still watching my mom. I had a full day of work. I had to and originally intended to record this with our field reporter, our drafted field reporter, has no say in the matter, Alessandro Gelke, who was at all 3 days of the hearings this week. But I was parked outside the bingo hall when Alessandro could talk. So I took a lot of notes. It was a bad reception, so I couldn't record that episode. I did not record at the time, but I took a lot of his notes. He forwarded me notes through Twitter. So I have extensive notes from him. I checked up on Cajun Johnson, who is a plaintiff. He was there. He recorded an Instagram account, checked up on CB Dalloway, checked up with other people that were in attendance. So I think I have a pretty good idea overall what took place during the 3 days. So I thought I'd run through everything and give you some input on that. Also want to know, I'm trying to speak slower because I've noticed something on previous episodes. I'm a Mrs. Malaprop on a lot of these shows. I heard a clip from one of the previous shows and I was a little embarrassed. If you're not aware, Mrs. Malaprop was a famous theater character who misused words all the time. And I noticed I misspeak a lot. So I'm going to try to be a little more careful. Most noteworthy recently, I think last episode, they said Boots beat up Virgil Ortiz, which is a fight that hasn't taken place yet. That's the next one. It was Xander Zayas that he had to fight with over the weekend. So that was a little embarrassing. So I am going to try to keep my to make sure I speak a little more carefully so I don't make the errors that I have in the past. I'm sure that will fall apart 10 minutes into it. So let's start talking about this hearings and we'll go somewhat in order. Let me do a quick summary of what supposedly happened. There were 3 days of hearings we just got through. So this week on June 30th, which is Tuesday, they had testimony from UFC matchmaker Maynard, I guess full name Michael Maynard, but Maynard. And it was mostly consisted of cross-examination by the plaintiffs and defendants' attorneys. They covered deleted messages. They talked about Dana White's diminishing role. They talked about device collection privacy. So that's the 3 things they talked about that day. Then the next day, on July 1st, 2026, they had the testimony of the court-appointed expert, Eric Whedon. And so they went over the programmatic deletions. I believe that was mostly about Tracy Long and phone resets. And then there's a PM session, which we will get into later because that's probably the most interesting thing that happened all week. And then finally on today, the day I'm recording this, Thursday, July 2nd, Sean Shelby came in. So let's go over the testimony, starting with Mick Maynard's on June 30th, where he was apparently the plaintiffs extensively challenged him during his cross-examination, where they pulled out his own text messages, WhatsApp messages to counter his testimony. and they were suggesting he was not being entirely truthful or compliant with the document preservation rules. And so here are some of the ways that I was told that the plaintiffs challenged these assertions. One is he used Dana White's name as a cover your ass excuse. So Maynard and the defense counsel asserted that Dana White's, and this has been asserted before. This, I'm not sure on this note if this was, I'm sure it was, they brought it up again, but this had been brought up several times. That Dana White's day-to-day involvement in matchmaking and contract negotiations has basically ended. So to counter this, the plaintiffs, they presented a December 2022 text message, apparently, where Maynard told the UFC accounting executives that he was waiting on Dana to determine if two fighters would be paid their show money for a canceled fight. As you can tell, I'm having trouble reading my own notes here. So this is secondhand notes, hearsay from someone else that was directly there, but they took extensive notes, and I think these will overall be pretty good. So Mick Maynard was confronted by this note because he said that he uses Dana White's name as a cover your ass. So there was a text message showing that Maynard told a UFC accounting executive that he's waiting on Dana to determine if two fighters would be paid their show money for a canceled fight. And so when he was confronted with this text, apparently Maynard laughed and then provided an explanation where he claimed that taking 6 hours to respond probably means it was Hunter Campbell who's going to do the responding, and that he regularly lies about waiting on Dana as a CYA, cover your ass. Now, to be clear, I'm not sure if he used CYA on the stand or cover your ass. The abbreviation was just relayed to me, but that's what he supposedly said, to keep people at bay. And because, White is harder to get a hold of. So that's what he said. This forced the court to consider whether Maynard was lying to his coworkers in his text. So was he lying? This is the part that's brought up. Was he lying to his coworkers about, waiting on Dana White, or is he lying on the witness stand to protect White? So he's lying to someone. He's either lying to his coworkers that he's waiting on White, which he apparently is not waiting on White, or he's lying in the court to protect Dana White. So you just make of that what you will. And then the plaintiffs then confronted him with his deleted messages. So Maynard testified that he understood it was, that it was his duty to preserve all records, business records, everything related to the business. But then the plaintiff's attorneys, they brought up the hard evidence, apparently, that he actively deleted messages during business negotiations. And so they produced a 40-page WhatsApp chat log, and I know it's 40 pages because this is the one that we talked about. This is the separate lawsuit in Brazil with Marcelo. And I'm drawing a blank. I need Stephanie here to get. Marcelo Brigadeiro came to me, the manager down there. That was the lawsuit in Brazil that produced a large amounts of text messages or communications between them. Actually, it was WhatsApp chats. And so they pulled that from that suit, and they showed multiple instances in the with the phrase deleted message, whatever it is in Portuguese, in Maynard's communications with that manager. And then they also presented a separate chat with another manager showing, I think it showed Maynard deleting a message right after discussing a fighter pulling out of a bout with a suspicious injury. So Maynard claimed that there was nothing nefarious about these deletions. So he testified that he only deleted messages if he sent them to the wrong person or had information wrong, like the date was wrong, or changed his offer, idea of his mind about an offer and wanted to delete it, something like that. Or he needed to rephrase an angry message because he didn't want to, he thought it was offensive, things like that. And I guess, again, you have to, do you believe that or not? Because at the same time, the plaintiffs brought up, they challenged him on this because he was supposed to preserve documents related to the UFC litigation. And so this involved the Brazilian manager, so he's supposed to preserve that. And so they also brought up that because Maynard's text messages were exhibits in that case. So Maynard claimed that he had no clue he was supposed to preserve documents for, I think it was for the Brazilian case. I'm a little confused right here. For the Brazilian case, and then apparently he also stated that he had no idea that the lawsuit existed until he read an article about it and his text messages. So I'm not certain if that's referencing to a different article. It possibly could, or what we did on our Substack, because I think we were the first to bring up the actual text thread, the WhatsApp thread, before anybody else. And so, and also on the June 30th, the Maynard testimony, he was brought up a few questions about fighter pay. So I have a few things about fighter pay discussed during that. And so he negotiates base pay, which is, your show win money. And so he was questioned about that. And so the plaintiffs, I guess, brought up text messages to question Maynard how specific contracts were finalized. And so he apparently noted some contract. I'm not sure what fighter was, but the fighter was offered, I believe, 30 and 30 per Dana. That's what I was told, 30 and 30 per Dana. And so this is what the plaintiffs presented a text thread showing that the fighter would get 30 and 30 per Dana, which again suggests that Dana White's involved in the negotiation. And then, but Mick confirmed, according to him, that the decision came via Hunter Campbell. And then and another one, Maynard reported that a fighter, I think it's Juliana Pena, I have a note here, was asking for 100 and 100 to match another fighter's purse. And Mick countered that with a 70 and 70. And then there's a note that Dana White weighed in, apparently left an audio message for Maynard to go up by 2, whatever you guys, go up by 2 apparently. And then Maynard explained by 2 meant go up by 2,000. So that would suggest to me that they were going to offer Juliana Pena a 70 contract. Every time she won, it'd go up by 2,000. So 72 and 72. But that doesn't really match the formula they normally do. So I don't know if they're doing that just, that's a mistake during the testimony, or if they were just kind of screwing her over, giving her a bad deal. So, and then they discuss, paying show money for canceled fights. They talked to Mick about that. There's a text apparently sent to UFC accounting stating that he was waiting. This is the one where he's stating on waiting on Dana to determine if fighters would be paid their show money for a canceled bout. And then, we know that they pay fighters sometimes when the fights are canceled. But again, they're trying to show that Dana White has some input on that. And then determining the post-fight bonuses they brought up with the defense counsel. This is the defense counsel that actually asked him, Maynard explained how it is decided that fighters get a post-fight bonus. The performance of the nights, the fight of the nights, which I think they listed as 100,000, but that's only most recently during this case, they were 50,000 for the bonuses. And in Maynard's answer apparently was that because Dana White is no longer present for the early fights to give input on it, that he's no longer involved. Instead, at the end of the night, Hunter Campbell, Sean Shelby, and Mick Maynard get together to do the bonuses. And I'm not sure if that's true or not. I have no way of knowing, but that's what he claimed. And so that's on the negotiations, the offers on that front. He was also he was asked a bunch of questions. I know he was asked about the class action waiver, and he was asked if he knew what a class action waiver. Okay, apparently he was asked about if he knew what a class action waiver was, and Maynard answered, "No, I don't." Again, I don't know if I believe that or not. I guess you have to make up your mind. Then he was asked if he knew whether class action waivers are included in any UFC contracts. And he replied that he was not aware, which, okay, I guess the matchmaker is not aware that they're putting in class action waivers. Again, make up your own mind on that. And then he was asked if any fighter or their attorneys, representatives, managers, whatever, have raised questions about the waivers, have asked him about it during negotiations, and he said apparently that he did not recall. I almost believe this because I believe speaking to a number of fighters, speaking to a number of managers, first, the number that were not aware of the waivers is, some were, obviously some were, because some took advantage of it and discussed it, but some apparently were not aware of it or not interested, like they did not examine the contracts at all. So as sad as that sounds, I think it is somewhat plausible that perhaps Mick Maynard, because if you remember, Mick Maynard said before, we talked about the other day on some notes we got, that he does not handle the top fighters anymore. That goes to Hunter Campbell. So I am of the opinion it's possible that those questions, fighters that ask those questions, might be much more likely to ask Hunter Campbell. I mean, it still seems somewhat unlikely, but that no one would ask about a class action waiver and that he would know nothing about it over the years, considering it's also in the center of this case. But that's the part. I mean, was he saying, and I was not there, so I don't know for sure. Is he saying that he was not aware of it at the time, or is he still not aware of it? Because it sounds like the notes that I have here, it sounds like he was saying he was not aware of it, at all now, even, which I find a little hard to believe, considering that's the centerpiece of this case, at least one of the cases, the Misha Serkinov case. You think he'd have some inkling what it is now, especially also after, fighters like Francis Ngannou took advantage of the previous contract with the sunset clause and other provisions in the contract. You think they'd be aware of those added provisions at this point, but apparently he's not. And he was also asked if he would be involved if a fighter, the representative, wanted to negotiate the arbitration or class action waiver. They want to negotiate it out. Not that they just asked about it; they wanted to negotiate it out. And then he said no, he would not, and that's Hunter Campbell handles that. So, and there was a few managers, their names popped up. The ones I know, Alex Davis of the Brazilian manager, again Marcelo Brigadeiro we mentioned, Jason House was identified in it apparently. I'm sure some others were as well, but that's the three that were said to me. And so that's the Mick Maynard testimony. So that was the entire June 30th day was taken up with him being questioned. But then we get to the next day. And I almost want to skip this day and come back to it, but we're going to go in order because this is I think the biggest, most important finding of the 3 days. And this was the court ordered a neutral expert on the data collection expert for the phones. Eric Whedon was called in to testify to go over his reports for the judge. And you could tell by just coming in today that based on Cajun Johnson's Instagram post, that the plaintiff side, the fighters and the plaintiff, their attorneys must have been very, very happy of which direction this case was going. Because, you can kind of tell probably from some of my disbelief of some of the answers, apparently, that Mick Maynard said. It just, some of them are, the amount of stuff lost, it just seems egregious. It seems it's hard to believe that the amount they could lose, and that there might be not more to the issue than just, even if it was just laziness and not being careful with the material, that's just as bad. But also you have to somewhat start assuming that there might be some sort of, I don't want to say conspiracy, but there's some organized effort to delete material, because just the amount and across the number of people and the overlapping dates. And so it looked like, the plaintiffs were probably thinking that their motion to strike might be granted by the judge, which means the judge might have just a nuclear reaction ruling on this case. But then we get to the testimony of the court appointed. This is the guy the judge himself appointed as a neutral expert. And so he was brought in, and there were several issues raised, and apparently there was a substantial data error regarding a white phone, where Whedon he had to make a correction to his report on the stand regarding the date of one of Dana White's devices. I believe it's I think it's one that might have been lost and recovered. I'm not sure, or the one handed in before that, I believe. And his written report claimed the phone was reset. Yeah, this one was handed in earlier. Reset. No, this is the one they just found and gave to him. Sorry, I apologize, because the dates here, I can tell that. The written report claimed the phone was reset on November 26, 2024, based on the timestamp, apparently, of the file that was deleted. However, when Whedon was on the stand being questioned by the judge, he brought up, apparently he admitted he had failed to account for the time offset. So the phone was actually reset on May 6, 2026. While it was, in his custody. And so Whedon testified that the phone reset on May 6th. I hope I'm reading this correct, my handwriting. While I was attempting to guess and enter the passcode because to gain access to it, although, and then I think he said he did not believe he had entered the passcode incorrectly. So the defendant's attorneys got, they took advantage of this. I think got very critical of Whedon for not being candid previously about how he had handled the phone, and that the fact that it had been wiped in his labs instead of been wiped before, because according to them, now we'll get more into detail on that in a second. That'll be the stuff I'm analyzing on my own. That's not stuff from the what I'll be talking about in a little bit will be stuff I'll be analyzing my own, not coming from the hearing. But it makes sense that the defense would find this, would jump on this because, if it's wiped before he gets it, right, before it gets in the possession of the expert, then it looks much more likely that the UFC was hiding something. They were not preserving evidence. But if it's wiped, no matter what reason it was wiped, but if it was wiped in his possession, then they can make the argument that it was Whedon deleted this material and they had handed it over properly. And then there's another thing during cross-examination. This was also pointed out to me, and I couldn't somewhat believe this. The judge was going over some of his mathematical formulations on an Excel sheet that was, that was projected in the court, and he was confronted about a bullet point on it, right? And there was data gap, so he was supposed to explain it, and so he could not explain the report, like he couldn't figure it out. And then he also told the judge, that the data gaps were supposedly indicators of, manual removal activity. And so, which would look bad for the defendants because they're manually removing the data means. But on the stand, then Whedon admitted that his conclusion should have been removed from the report. In other words, he should not have come to that conclusion that there were indicators of ongoing manual removal activity. He explained apparently during this that that he accidentally left in this text from something previously. So the judge, obviously Boulware was not happy. Apparently there's a recess. He kicked everybody out of the court, called the attorneys up. And so the judge noted that these issues, including the likelihood that fucking the expert might have wiped the device himself, and then the lack of explanation for the wipe, the mistakes in his report that he couldn't explain on the stand, and I guess there's also some indication the judge brought up that Eric Whedon might not have read his own report, so that all destroyed his credibility. So the judge concluded that he could not, in good faith, use the report, and had Whedon's testimony and findings struck from the record. And so Whedon was excluded from the case, exercised, removed all his testimony. So basically all that time with Whedon and the phones, was wasted. We'll get to that in a bit. But one tidbit, though, I guess Whedon did mention it, that you could potentially attain Apple records regarding the white phone. And that's important about that, he was talking about that there's one way an iPhone can be completely wiped and removed to its factory setup is if the remote kill code or command is sent to a device by the cloud, I guess. I'll have to look that up exactly how it works. And so what Whedon said is that there's one way to confirm that, is that one way to confirm that he did not delete that or cause that deletion when he was trying to enter the code on the iPhone, is that the kill code was sent by Apple because the owner of the phone, had called it in and asked for the phone to be deleted. And so if they decide to, and maybe they will, if they decide to subpoena Apple, maybe they can get a record of that iCloud account to determine whether a kill signal was sent. And that way we'd know if it was Mr. Whedon or a kill signal. Now, the defendants, and this is me just, theorizing on my own, coming up with a hypothesis here. I believe the defendants at that point will probably argue, though you'd think they'd argue something along the lines that, well, we lost the phone. We were not aware of its location at the time. So we sent in the kill code because we didn't want anybody finding this phone and getting access. And then we found it, retrieved it, and, we turned it on and did not disable that. They might be able to argue that. I'm not sure how that would work, but that's, again, and they would only have to argue that, make that kind of argument if it was found that a kill code was sent in through the iCloud. And so, again, to go over the specific issues surrounding his lack of candor, he apparently wiped a phone without disclosing it, which, that's just insane. And so the defense explicitly accused Whedon of, not being candid about that because he had submitted, if people remember, he had submitted multiple reports knowing that that one of Dana White's phones was wiped, reset while in his lab, yet he never disclosed it in these previous reports that have already gone out to the judge that have been brought up in the case. And so the judge noted that, I think the judge noted that the device, potentially wiped the device himself. He must have said that because that's why he kicked him out of the case. And then he also notes there's substantial date errors in his document. About what date, was a reset on November 26th before, or the May 6th. Then he failed to, remove the retracted conclusions in his report. So it was a bust news report. And I know there's probably some conspiracy theories going on. And you probably can't help it that there's some conspiracy that maybe he sunk this because this is in some ways a godsend for the defendants. And I'll probably talk up to that more at the end, but at the same time, as much as it's a godsend to the defendants, this guy has kind of ruined his career as a major, as a data analyst of this type of forensic data analyst that's used by courts all the time. They are considered one of the premier. Kroll is considered one of the premier companies that does this, right? And he is considered, he's a director there, does court case all the time, recommended all the time, apparently, probably testifies all the time. So he probably has just a large number. As an expert in this, you can probably make a lot of money. The amount of money in these reports, he's probably been paid hundreds of thousands of dollars in the last couple of months to do these reports, maybe more than that, maybe $1 million, somewhere in between 100 and $1 million. But a lot of money paid. No one is going to hire him again for this. None. You can't go before a judge after another judge says your work is completely fucking erroneous and can't be used. So he's been excluded. When you're excluded from the expert opinion, stricken from the record in this way, from your own gross negligence, your own incompetence, it seems like, and also misleading material. It's just like you will never be an expert in a court case again. So that's I don't know if he has tons of, he bought Donald Trump meme coin, made a ton like some other people did on that when it first launched, or what, if he doesn't need the money. But his future in this profession is just gone because of this. So I'm not certain someone would do that. Now, again, the conspiracy theory is probably going to say something like, the TKO, Endeavor, UFC have so much money that anybody would jeopardize their future career for the type of money they're offering. But if it comes out, you're even doubly fucked. So I'm just not. It seems to me, it just seems the more plausible. The Occam's razor here is this guy was just incompetent. I don't know if maybe had something going on, maybe he has a drug problem, drinking problem, and or maybe he's just been faking it his entire life. And he got into this situation now and it fell apart on him. But so that was Whedon, and that's the biggest thing that happened. And that was let's put it, not to put it lightly, that was a disaster for the trial or the hearings, because it's going to have repercussions going forward. I'll get to in just a second, but first I'm going to get over the little bit of Shelby, because Shelby was basically, apparently, I have the least amount of notes of that because everybody was exhausted. Gelke was exhausted talking about this at this point. He had to get some sleep. But Shelby was also very similar to Maynard. So, we could cross-reference a lot of those comments with the Maynard. But, I mean, and obviously, to be fair, I got to be fair about this and open and if you've listened to Gelke on the show, he sides with the fighters. He's 100% on the fighter side. So you got to take everything with somewhat a grain of salt, but he also tries to be impartial when he's talking to me, personally about this. He's trying to give me the straightforward what he saw and heard. But, Sean Shelby was asked a bunch of questions, including, how much was he spend on the fighters? Does he have a budget or anything? And there was no budget. Apparently he was asked about this specifically. How do you know what to spend? Is there a chart? Is there a system in place? And he said that there was nothing like that in place. They just apparently just kind of know how to spend. And again, I find that, unless there's details missing from this account by Gelke at the hearing, I find that hard to believe because, as you notice from the previous lawsuit, there was discovery. We have documents of the UFC having basically just, they have their whole pay tier system laid out, which percentage of fighters fall under each. It's very formulaic. And so it just seems, me personally, seems somewhat unbelievable. And they used this defense before. In the previous lawsuit, all the matchmakers made this argument as well. That there's no paid tier system, there's no formula, nothing like that. They just kind of, fighters fall in the spots and they just kind of know. And none of that seems very believable to me, considering how structured how everybody falls into pay tiers naturally, it looks like. And then on top of it, in discovery, that we have these pay tiers and that we have a certain percentage of the pay looking forward is going to go to the fighters. All that suggests to me that there's a system in place. They should know what fighters are supposed to make. But he says no, and that even that there's no guardrails towards their spending on fighters. In other words, there's nothing that stops them from start offering more. It's all based on them. So again, I have to question, well, if that's the case, I mean, if fighters ask for more, then are you the one to blame for not paying fighters more, or is someone else to blame? Could the pay go up wildly year to year? It doesn't seem to happen. There's all these other things that kind of come out from that question that just don't add up to me. So I guess he was asked guardrails, but he couldn't understand it because none of them could understand it, Gelke, because it just didn't make sense to him. And then they asked him again about, is Dana White involved? And Dana White, he said, no, not since 2017. But again, they brought up a lot of the same type of quotes and stuff where, you're talking to Dana White about bonuses, about certain fights, about, getting permission from him. So it seems like he has some involvement. And, on Dana White, before, I think they testified Dana White that he's at the 1 yard line. And that might be true. Maybe a lot of the heavy lifting in the contracts is Hunter Campbell and Shelby and Maynard. But it does seem like they run, some of it or a lot of it by Dana White, which, maybe it is the 1 yard line, but it seems to be a very important last 1 yard line. I mean, that's when you punch the touchdown in. So that's a pretty important spot. So again, I have a little disbelief on that argument. And then they asked him about the arbitration agreement, class action waivers. He again was, knew nothing about it. He was ignorant of it completely, which again, take it what you will. But so that was Sean Shelby. Nothing, just reinforcing we've heard testifying again and again, that Dana White is not doing anything with the matchmaking negotiations, even though the plaintiffs will show tweets and messages and other things, voice messages and emails and other stuff that seem to show that Dana White's involved somewhat in the matchmaking and negotiations, that he has some input on it, but they're claiming he has almost none. And then they're claiming that the arbitration, that they were aware of the litigation hold and they didn't really have much of a defense about why they deleted material on their, they weren't supposed to, but maybe they got confused. Apparently, that's their defense. And they were not aware of arbitration agreements or class action waivers. Those are alien to them, something they don't deal with. And so it's very similar testimony. Again, you have to make up your own mind if you believe it or not. But to get to the Whedon one, this is the interesting part because if you look at the testimony, at least the way it sounds, of Shelby and Maynard, it sounded terrible. I mean, yeah, the UFC really has had no defense for the most part for these spoliation issues. Uh, just it's just embarrassing by him in many ways, and it resembles a lot what's going on in the WWE case where they got nailed on that because they are not preserving material that they know they're supposed to, and there's stuff they're hiding from the courts. And so all that looks bad. So it's understandable. I think the plaintiffs, I think their opinion was they're going to come in and they're going to just get a death penalty on the UFC on this in a motion to strike. In other words, they're going to strike a lot of the UFC's defense, which means they kind of forfeit some of these case materials, some of these decisions. And that's not happened. The judge at the end of today apparently denied the motion to strike by the plaintiffs. And so that's not a loss for the fighters, I should say, for the plaintiffs, because it's just that they didn't get this results. Now, what's going to be bad for them, if you think about it or look at it, is because of this Eric Whedon situation, they're kind of back to square one, right? So that it's going to be months and months of going back over this material. They also don't have an impartial, neutral expert. The judge instead is going to order apparently both sides present an expert of their own, which so right there, you're gonna have both sides an adversarial position, right? You're gonna have dueling experts. He's gonna bring in, he's gonna pivot to the typical dueling expert thing, which we've done several times in that courtroom over the years in the different cases. But he'd been hoping to avoid that. He said that last time he wanted to avoid it, and now he's bringing dueling experts. And the problem with dueling experts is it's not like it gives you an impartial view of what really happened. You're going to have the plaintiffs make a case and the defendants make a case, and their experts are going to miraculously find out exactly what they want to hear. That's kind of how it works. But both sides will appoint their experts, present testimony, and then they have to determine the data access and the methodology and all that. And so, the judge, I think, instructed the plaintiffs to consult an expert to determine what methodology they plan to use, because then he has to present that to the defendants, and so they can, then they'll argue about, oh, that'll give up too much information that we're not supposed to reveal. And so the judge ordered the expert to cease all of his work, and then to return all the UFC's drives. Basically, just let's just delete and burn anything you did. But to get back to all this Impact's case, it's not just going to drag it on. It's also, this was kind of a miraculous moment for the UFC on that, because, as I mentioned, it seems like, just reading between the lines, hearing all the testimony, reading the transcripts from the previous one, they were kind of fucked on this spoliation issue, because again, they had really no defense. And so the problem would have been is you have 3 court cases involving, well, fourth, I'm not going to bring up really the fan one because I don't really follow that much, but 3 court cases. You have the Serkinov case, where Serkinov is arguing that the arbitration agreements, class action waivers, should not be enforced because they were improperly used by the UFC. And so they should not be enforced. And if they're not enforceable because they break Nevada law, then we've got to, they're not enforceable, so they're not acceptable, which means all the fighters that signed an arbitration agreement class action waiver should be allowed to be involved in the Johnson v. Zuffa case. And so with the Johnson v. Zuffa case, they would add tons of fighters, about over 50% of the potential class members now of the Johnson class, everybody that fought from July 1st, 2017 to now, I guess probably well over 50% now, have signed those arbitration agreements and class action waivers. So that'd be huge. And the judge in that, remember, that takes just an order. So the judge just makes a determination. If he determines that there's no way to properly rule, because the defendants, in his opinion, if he rules that the defendants have intentionally destroyed all this material and they have no defense, then he almost automatically can rule in favor of the plaintiffs and throw out that arbitration agreement because he has no way to make an actual analysis now because of the current Supreme Court rulings and just the way arbitration agreement rulings and the Federal Arbitration Agreement laws, the way they work. It's possible, in fact, it seems likely based on what has been said in the court before, that those arbitration agreements might be enforced. But if you delete all your evidence of how those were offered to fighters, then you've basically made it impossible for the plaintiffs to make their case. And so the judge in that case, if he ruled that you intentionally deleted it, would probably, it seems likely would rule in favor of the plaintiffs and throw out those agreements. But now the difference is that the plaintiffs can argue that, in some ways, either it's going to be dragged out longer, or they can make an argument that we did not delete all that material, that there was plenty of material to work with, but this Eric Whedon guy deleted it. And so because he deleted some of it, the key material that you could have seen and seen how we did it, you should not rule. You cannot punish us for something we did not do. And so that's going to be their bailout. So that's on the Serkinoff case. In the Davis case, some of the same discovery needed, and the discovery is missing. Well, it's a bench trial, so the judge would make his own ruling. In the Johnson case, he would instruct the jury about that evidence if he decided that the plaintiffs had intentionally destroyed it or hid it or whatever. But again, you get with this Eric Whedon thing, it kind of changes the what possibly might be there. It doesn't mean that the judge doesn't end up ruling that way anyways, but it gives the UFC throws them a lifesaver, right? It throws them a lifeline because honestly, just talking to everybody I knew, it's following the case. It just did not look good for them at all. The UFC, they looked like they were again royally effed, and this threw them a lifeline. It doesn't mean it's going to hold up forever, but it's going to stretch the case out at least for them, and also gives them an avenue to go after to kind of defend themselves and why they have all this missing material. So that's bad for the that's bad for the plaintiffs from their side. They cannot be happy about that. They cannot be happy with this, all because of the neutral appointed experts, the court-appointed expert that belongs to neither side, just did a horseshit job. And not a horseshit like he found material that not in favor of one side or the other. Horseshit in the fact that it was so sloppy, it was useless, and so sloppy too that we don't know if he deleted material or not. So that's just I don't know other way you phrase it, just horseshit. So anyways, that was the results of the last 3 days. That's the notes I got. I spent a long time going over, combing through stuff, talking to Yelke. Got to compliment him for giving me a lot of information. Spent a long time on the phone with him, write these notes down. I probably got a few things wrong, but I will update them as we go along. When the transcript finally comes up, or some filings come from this, I can make sure that I've crossed my I's, dotted my T's. Intentional malaprop there, but I'll do that to make sure. But I'm pretty confident, at least, that I transcribed what he told me properly. So hopefully that's informative to some of you, the people that are interested in the case. And I want to remind everybody again that if you're not subscribed, please subscribe to our Substack podcast blog, which we do 2 episodes per week usually. The second half is usually behind a paywall, only $5 a month. Get you that second half, which we delve into a lot of the unreported stuff in combat sports. So recommend you subscribe. Beyond that, Stephanie, I'm sure will have a lot of comments, complaints about my performance today, but hopefully it was informative to everybody listening. Hopefully I also did not say make as many verbal errors as I often do. I need to correct that, but I hope you enjoyed that. So with that, everybody have a good night and have a good 4th. Stay safe.
Ow! Ow! Not the face! Ooh! Ooh! Okay, the face!